Thank you so much for watching Law School Made Easy at Law School Made Easy 256. We thank you so much for watching this channel, subscribing, and sharing our video. Let's keep sharing. Today, we are going to look at what we call an idea of a constitution in constitutional history. This is by far the first topic, and this topic is actually set. It is either number 1 or number 3 in every year, at least in a paper of constitutional history. They must trace an idea of a constitution. Remember, we agreed that this is a constitutional history paper, so we are tracing the idea of our constitution in Uganda. We are tracing the idea of our constitution in Uganda. So this first topic becomes very important. It lays the foundation for all the future topics. And today, I have been joined by Gerald Kabugo, as Counsel Gerald Kabugo, who is going to take us through an idea of a constitution to help us understand what do we mean by an idea of a constitution, how do we relate it to the different articles in the constitution. Counsel Kabugo Gerald, you are most welcome to this is Law School Made Easy. First, I want to thank you for making time to come to our show. You're most welcome. You can say hi to our viewers before we start.
Hello, our dear viewers. This is Counsel Gerald Kabugo here to help you. We thank you for watching. Thank you. Keep subscribing. Keep referring people to come and subscribe to Law School Made Easy. Here we shall always be sharing information. Feel free to send in your questions. We shall always attend to them wherever possible, and we can always make videos in regards to the various questions you always ask us.
Thank you very much.
So much to be part of you.
Members, keep the questions coming. Anything you want, we shall always respond. Let's go straight to an idea of a constitution. Gerald, I want you to tell us, what should the student first have in mind as we discuss an idea of a constitution?
Before a student thinks of writing to get the 25 marks of this number that stresses about an idea of a constitution, you must be in a position to let and inform the examiner. Can you backtrack where this whole notion of an idea of a constitution, constitutionalism, we hear about Tojikwatako, don't touch our constitution. What is this constitution? Where did all this begin? Is it our own making? You need to first trace back where did all this start. So you must be in position to let even your grandmother in the village, if she asked you as a law student at law school, can you tell her where did all this start? Because truth be told, this wasn't our own making. We copied it somewhere, and that's what the examiner wants you to trust.
So, Counsel, you're saying that the first thing is for you to appreciate where we got our constitution from.
Yes.
You must know that, like you said, it is not that it was our making, but we copied it somewhere. You are talking about the constitution we have today, the 1985 constitution. Okay, thank you so much. So let's enter into. I know there are very many points. I can try to give them out. We can start with Roman Empire.
Yes, the ancient Roman Empire.
Yeah, how can the student discuss ancient Roman Empire as a point?
Yes, ancient Roman Empire, as you are backtracking the idea of constitutionalism, we look at the ancient Roman Empire. Sometimes the examiner can tell you that an idea of a constitution is greatly traced with the ancient civilizations. They may not specifically mention the ancient Roman Empire or ancient Greece, but they may just say the ancient civilizations. It should come to your mind that now they are talking about what? Ancient Roman Empire and that ancient Greece. Specifically now with ancient Roman Empire, what do we appreciate? You must be in a position to tell the examiner what do we appreciate from the ancient Roman Empire, that we see that it is evident also in our current constitution.
So you are saying that when you're discussing ancient Roman Empire, you must give what those people brought, and then you see if we have them in our constitution.
Yes. How did we appreciate their setting that we see that even influence our constitutionalism, that even today it is evident
in our constitution.
Reality in our constitution.
But we copied it from the
ancient Roman Empire.
Give us their setting, number 1.
Their setting, number 1, they came up with the idea of citizenship. In this, they wanted to define what the status of a citizen, what duties and rights are accrued to a status of being a citizen. We all know that in the ancient Roman Empire, it was a concentration area, the way you see Kampala, it is full of very many people from all over the world. They come to trade. But now we see that there was trade vis-a-vis the state. Now they wanted to draw a distinction between the people who are Romans and those ones who have just come as foreigners to do with the business, because it would be very suicidal for foreigners who have just come to trade to start dealing with matters to do with the policy making for the Romans. Because at the end of the day, for example, if Kenyans came here in Kampala to trade in Matoke, and tomorrow Matoke is no more in Uganda, they go back to Kenya. When they have made laws for us, it would be very suicidal. But if it's the Ugandans who have made their own laws, that means the laws would still work.
They are actually binding on them because the laws are made by them.
Yes.
So you're saying the idea of citizenship was meant to limit on who participates in the politics, who is supposed to be a Roman Empire. If you're not, you don't participate.
Exactly. You just come and do business
and then you leave.
Don't participate in policy making.
Oh.
Yes.
So what does that lead us to in our constitution today?
Yes. After you have traced that, you have showed the examiner the idea Roman Empire came up, and the idea is citizenship. That is not enough just dropping it there. You must articulate that point to our constitutionalism. Where do we see this concept of citizenship? When you come to the 1995 Constitution, under Article 9, Article 10, Article
11 up to 19, it's actually 9 to 19.
Yes, you see it provides for various forms of citizenship in Uganda, by registration, by birth, by naturalization. You get all those various forms of citizenship. Perhaps the framers of our constitution, they copied it from the ancient Roman Empire.
And then put it in our constitution.
Yes.
And the role of citizenship is
yes, Article 15 provides for the duties, because where there is a duty, there is also an obligation. So they had to define what are the duties does the citizen owe to the state, and vis-a-vis the state to the what? To the citizen. And the duties of citizens, we can trace them under Article 15 of the 1995 Constitution.
So the best thing would be to trace the article which forms citizenship, yes, which is Article 9.
Article 9.
And then after you bring Article 15,
Article 15
which is the duties.
The duties of the citizen to the state.
Is there anything the ancient...
Yes, the ancient Roman Empire, they also went ahead and they came up with the idea of, they had their Senate. The Senate brings us now to a new point of what we can call present-day parliament. That as they had their leaders, they had somewhere they could convene and formulate policies for what? For their country, for their ancient Roman Empire. So they could sit there and debate policies. So this one is also evident under the 1995 Constitution.
So the Roman Empire,
yes,
we have agreed they brought citizenship, and now the Senate.
Now we see the Senate.
Senate is like our parliament today. Yes, sir.
When you look at Article 77, it creates the legislature. It creates the legislature. Yes. It creates the legislature. And under Article 1, under Article 79(1), it gives the role of parliament to enact and make laws for the what? For the country.
So our parliament today under Article 79,
yes,
clause 1, is the equivalent of the Senate.
Of the Senate.
So as a student, when you explain the role of the ancient empire, you bring out the idea of the Senate. And relate to Article 77, yes, and 79 in particular.
Yes, but
why are you starting with 77?
I'm starting with 77 because you cannot just jump to the laws minus creating that entity that is going to play the role.
Oh, so you begin with the article which is creating that.
Exactly what the Senate
so the legislature is at Article 77.
Yes.
That is the equivalent of
the Senate. In the
but now the role of the Senate then,
yes, which
is now Parliament, is at Article 79.
Under Article 79(1), that mandates Parliament to make laws. And when you look at under 79(2), it provides for, it can delegate some of
to other
entities to make laws, because
and that is the principle of the
legatus non potestate delegare. So that a delegate cannot delegate the powers that have been given to them. For example, when you find KCCA today making bylaws maybe governing that traders won't be on the streets anymore trading, they should be in the Nakasero or Chiseka. So all those powers, you cannot come and challenge KCCA for making such laws, such bylaws, because it is Parliament that has delegated it to them. But KCCA cannot redelegate again such a role
to any other body
to
make it for on his behalf.
A delegate cannot delegate.
Okay, thank you so much, Council. So I think
a student should be very careful when you are articulating these things. You must give us what the entity gave us, the ancient Roman Empire. Try to articulate. You don't confirm what you are saying, but you are just assuming perhaps it influenced.
Because still it is possible that the framers of our constitution may not have looked there.
Yes.
So as you bring it, it must be a test which is perhaps they could have you're suggesting.
Yeah.
Okay, I
Yeah.
understand.
Yeah, it is more futuristic statement.
And the same happens to Buganda argument as we relate.
Yes, the same applies as we shall.
So we can go to the Greece.
Yes, there is ancient Greece. Ancient Greece. What did the ancient Greece?
This is the second point of an idea of the constitution. Ancient Greece.
Members, don't forget we are backtracking where we got all this entire notion of constitutionalism. Where did it start from? What were the intentions of the people who came up with this idea of constitutionalism that has become of fundamental use in modern day-to-day life? So we go now to the ancient Greece.
Yes.
What did the ancient Greece bring about? Ancient Greece, for them, they came up with the idea of direct democracy.
Direct democracy.
Direct democracy.
Under ancient Greece,
yes,
direct democracy.
They came up with the idea of direct democracy.
Yes.
And here with direct democracy, wherever a problem cropped up in their societies, people had to gather and they merge up together and they start looking for ways how to overcome their challenges. So they had to convene all the timers. But you see that this direct democracy, it is no longer visible in our modern society. It has been replaced with the representative democracy. With representative democracy, this is whereby people vote leaders who can represent them. We always go to the 2026 is coming here. People always go into elections, they vote their leaders. Now their leaders, they will go to parliament and start making represent them, and the decisions they shall be making, shall be binding on their electorates. So we see that the idea of direct democracy ancient Greece came up with is no longer visible, but has been replaced with the representative.
Come again, direct, they could do. Everybody would participate.
Yes, everybody would participate. So they also came up with another idea of freedom of assembly and association. They could come together and they share knowledge. You know, no one has a monopoly over knowledge. So they could come up together. How do we see their assembly? You must give.
Let us first relate
yes,
direct democracy to the Constitution.
To the Constitution.
That one, Article 59?
Article 59 and 60.
That gives people a right to vote.
Yes, the right
so as you discuss the direct democracy voted by the ancient Greece, you relate it to Article 59 and
Article 60.
Okay.
Yeah.
Because you see Chapter 5 of the Constitution, it has the name representation.
Yes.
Reflecting what we just said.
Yes.
Okay. Then the other words?
Then
association.
Yes, you see that as they came together, that one we can term it as association. They had the freedom of assembly and association, so they could come together and share views, share knowledge about various factors that are affecting their societies. And that one we can perhaps it also influenced the framers of the 1995 Constitution to also include Article 29 that provides for freedom of association with all others.
Thank you so much, Council. Yes. So that is the ancient Greece.
Yes, that's the ancient
Greece. So far I have 2 points on an idea of constitution,
yes.
Roman Empire and ancient Greece.
Yes.
Now let's cross to the Magna Carta.
Magna Carta. Yes.
1215.
Our dear viewers, dear students, take note that you must articulate these things. Just going and cramming whatever happened in the Roman Empire and the ancient Greece will not earn you any mark. You must appreciate, and that's the why you are studying this course unit called the constitutional history. You must articulate. Articulation, you must appreciate how the history that you are backtracking has influenced the current events. And now to the
Magna Carta. 1215.
1215, the Magna Carta, actually, this was the first constitutional document that we see. It was enacted in 1215 in Europe. You see that Europe during the 13th century was characterized with a lot of absolutism and autocracy. The leaders were ruling with an iron hand. So there was need, for example, especially the issue was to do feudal exploitation, greatly depended on land. And that the feudal lords, they had the control to man whatever does happen on the land.
And they were tied to the land.
Yes, they were tied to the land, and they always got these lands from the king or the crown in exchange for service of military service and something incidental to that. So we see that they over-exploited the serfs. The serfs, you can look at, let's say, the peasants, the people who were using this land. So there was need also, the king was ruling in an absolute manner. For example, when you look in France, the factors that caused the French Revolution of 1789, you see that the king was ruling with an iron hand. There was need to restrain the absolutism. In other words, people had to feel that they are having a leader, not a ruler. So forces of change and liberalism start to heat up, and these guys come up with the Magna Carta. The Magna Carta was like a mirror of their aspiration of how they should be governed, how they should be led by their leaders. So they come up with the Magna Carta, and the Magna Carta came up with very many aspirations. So in other words, the Magna Carta being brought up by these guys, they were trying to reassert the rights and freedoms of the marginalized groups, and specifically the peasants.
That is the role of the Magna Carta.
Yes.
So what did they bring? What particularly, what things did they come up with? 2
to 4 things we can pick from the Magna Carta. They came up with the idea of right to fair hearing or fair trial. That if someone has been arrested and brought before any tribunal or court, they should be accorded a fair hearing. Remember, fair hearing is as old as mankind. You remember in the Bible, when you read in the Bible, when Adam and Eve, they sinned against God, God also called them, Adam, where are you?
And
to accord them
a fair
hearing. So when these guys see that the king and the state, they have done away with the principle that is as old as mankind, they want to call the king back to order. And now in the Magna Carta, they are asserting their fundamental inherent human right of right to fair trial. So, and how do we see this? That if someone, for example, when you look in France, you remember the letter de cachets? The king could issue each and every year over 78 of them, that whoever he is not pleased with, he could just say that let that one be taken to what? To jail. And all these people could languish in prisons. So there was need that if someone has done any crime in society, they should be brought before justice, and they should be judged for what they have done. If there is punishment already prescribed for the law they have contravened, they should be given punishment. Let's say we are sending you for 7 years in prison. We shall be knowing that after the 7 years, someone will be free and come back to society. To do away with the former that they don't know where the person is, when will he be brought before court, even when he is brought before court, will he get justice? So how do we appreciate this concept
into our constitution?
Fair hearing. Yeah. When you look at Article 28, the whole of
there are 12 clauses.
Chapter 4.
Chapter 4, yes.
But to
28,
be specific,
just 12 clauses. From 1 to 12,
yes.
They are all very important.
Yes. You see that right to fair hearing, that a person actually in criminal matters is presumed to be innocent. An accused person is presumed to be innocent until proved guilty or pleads guilty.
That was a principle set in Wilmington.
Yes, Wilmington versus DPP when we cross to criminal law. Yes, we also see that still under Article 28, an accused person has the right to legal representation or right to counsel.
To be also told in the language they understand.
Under Article 23. Yes, you can articulate Article 28 that an accused person has the right to legal representation. And also under Article 23, an accused person once arrested, they should be told in a language they understand the nature of charges they are being charged with.
So that you relate the fair hearing in Magna Carta,
yes,
to Article 28. Any other thing that they brought?
We also see that they came up with the writ of habeas corpus. Writ of habeas corpus. Like I've told you, these feudal lords, whoever, for example, failed to pay the taxes for using the land of the feudal lords, these people were always thrown. Thank you so much. These people were always thrown into prisons. So they come up with the idea of writ of habeas corpus. What is habeas corpus? That produce him dead or alive. So that if you have arrested a person and you've put them under state custody or police custody, you should bring them to before courts of law to be read the charges they are being charged with. If found guilty, they should be convicted. So this writ of habeas corpus, it is to compel the state to produce the people that it has detained.
And it's also very important, it is inviolable, that you cannot reject it. The moment court issues the writ of habeas corpus, you cannot reject it. You just have to produce that person wherever they are. But you cannot claim, when you know a person where he is, and then you say, I am issuing a writ of habeas corpus.
You will be an village lawyer. if you went and applied for a writ of habeas corpus,
maybe what does writ mean for the first years? The writ.
Yes.
The word writ.
Writ just simply means a legal way of bringing a course of action against someone. So we see that they come up with the writ of habeas corpus. So this one is also evident under Article 23, under the 1995 Constitution. Article 23 clause 9. It provides for a writ of habeas corpus. And the same is also provided for under the Judicature Act, Section 39.
And also Article 44.
Yes.
Under the non-delegable rights. Under
and this right to writ of habeas corpus is a non-delegable right.
It cannot be denied.
Yes, under Article 44 of the 1995 Constitution, this right cannot be denied. It is absolute. No one can tamper with it. So we get that. That was writ of habeas corpus.
Anything else in the Magna Carta?
Yes.
Because the question can come, asking them to talk about Magna Carta and then give the other factors. So
yes. Sometimes a question can come when the examiner has made Magna Carta or the ancient civilizations as the stem of the question. For example, they may set a question that, to what extent was the Magna Carta responsible for the idea of constitutionalism? Here the examiner expects you to exhaustively look at the Magna Carta vis-a-vis the other factors. Here you will not talk about only one contribution on the Magna Carta and transit to the other side. And you must look at it in totality.
And normally in the first year, that's what they ask. They get one, they say ancient Greece, they put it in the question, and then we can add ancient Greece and Roman Empire. Then you talk about them exhaustively, and then you must give all the other factors. So we can now cross to, we can have Magna Carta first.
Still under Magna Carta, we've seen they came up with the right to fair trial. Then we see the right writ of habeas corpus. Then they also came up with the idea that there shouldn't be taxation. There should be no taxation without legal representation. That for if any tax policy should be brought up by the state, it should be debated. People should be part of the policy that has been brought, a policy of taxation. That they should, in other words, they shouldn't be as if they are being coerced and being subjected to this kind of policy for taxation. At the end of the day, the state will just end in enacting the law that is demanding for taxation. But it is the peasants or the citizens who are going to be subjected to this law. Therefore, they want to be part of the negotiation that is bringing about this law. That there shouldn't be taxation without representation. And how do we see this? When you look at Article 152 of the Constitution, taxation and URA, it creates taxation. It provides for taxation in Uganda, and there it also creates URA. URA is also given that mandate to collect taxes on behalf of the government. I think those ones who can backtrack those days in the early 2000s backwards, we had that kind of taxation, whereby people could just be grabbed. You don't have a ticket that you paid that taxes, you could be imprisoned.
We had a man in our village who was about 40 years.
Yeah.
But every year he would be a student, put on a shirt, and he would be moving in a uniform because he doesn't want to pay Omsoro Womutwe.
Okay. Yeah, okay. So you see that that kind of taxation was very inhuman. It was so degrading. People could be arrested as if they have stolen a chicken. So, any taxation to be implemented, it should be debated. People shouldn't feel as if they are being coerced. That's why these Magna Carta guys are saying there should be debate on which kind of taxation we are going to be
So
subject
you relate it to Article
152
152.
and 153.
Anything else with the Magna Carta?
Yes, we also see, you can also add on Article 153 that creates the consolidated
Fund,
yeah.
yes,
That
because
after
you
you
can't
are
collect what you don't get to keep together.
Yes, after you are collecting,
Then
now bring it to the consolidated fund, where now the Minister of Finance, Planning and Economic Development will start to cut and distribute for the rest of the citizens. Yes.
Any other point on Magna Carta? I think that they can do the research.
Also, maybe the last point was that there should be a separation between the state and religion. Remember, in France during the French Revolution, there was a lot of intimacy between the state and religion, specifically the Roman Catholic Church, and we see what ended up. That you remember those questions you used to do in divinity. The politics and religion don't mix, discuss. Because you are saying
politics and religion
don't mix,
discuss.
Because they are trying, these questions were trying to trigger our minds. What can happen if you are tainted with politics, yet
And
you are
religion,
also masquerading as a religious person? You cannot play the two roles, because this way you'll be a devil's advocate on the other side.
And you see that in France it was mainly against the Catholic Church.
The Catholic Church.
That they had not really governed well.
Yes.
Okay,
And
so relate that to Article?
And given our nature, for example, Uganda, which is very many tribes, very many beliefs, it is very incompatible if at all Uganda adopted any state religion, and that's why Article 7 is pronouncing itself that Uganda shall not adopt any state religion, because they are appreciating
Article 7 of the Constitution.
Yes, Article 7 of the Constitution. They are appreciating the consequences that resulted.
They picked a lesson that elsewhere where the church intervened in politics, there were problems. But now here, we say we shall not have a state religion, but we shall respect all religions which are in the country.
And I think you can appreciate the stand of Article 7, because normally when you hear anyone has been shot along the streets of Kampala and wherever, the Ichulis, the Chirumiras, always Muslims will be grabbed. You just imagine if at all, let's say the Catholic faith was a state religion, they would say it's because it's the Catholic Church that is now the state religion. Now we are being marginalized because we are not the state religion. In other words, whoever will not be subscribing, assuming Uganda is a Catholic state, whoever will not be subscribing to the Catholic faith, there will not be freedom of religion, you get, because they will all want them to coerce them.
Because actually where the all state religions must be in there. So I wanted us to conclude, but the point of philosophers, let us briefly talk about the philosophers, then we shall briefly talk about philosophers, and then African setting, then the bills of rights, and others, they'll do their research. Okay. Let's do philosophers first. It's very hard to talk about the idea of constitutionalism without talking about the philosophers. And specifically here we shall look at Montesquieu, John Locke, and Rousseau. Yeah. Jean Rousseau. Yes, Jean Rousseau. Those ones who did some French revolutionary history. Congolese name. Yes. Let's look at Montesquieu. What did Montesquieu tell us? What idea did he bring about? Montesquieu came up with the idea of separation of powers. He authored his book titled The Spirit of the Laws. For him, he came up with the idea saying that for justice to prevail in society. But before you go to Montesquieu, what should students write about philosophers? What are they supposed to write? Yes. Their writings, their sayings, before we enter into Montesquieu briefly. When you're talking about philosophers, you should interest yourself in 3 philosophers. That is Montesquieu, John Locke, and Jean Rousseau. Jean-Jacques Rousseau. So each one, they did a lot of writing, but we are not interested in all. We are only looking at what is in regards to constitutionalism. Only trace out what is in regards to constitution. What is useful to our constitution, that we might have picked from them and replaced them in our constitution. Yes. So when you can now enter into Montesquieu, for him he came up with the idea of separation of powers. That if there is a government, for their justice to prevail in society, there must be 3 organs of the government, and that is the legislature,
executive,
and the
judiciary. And for him, he was saying that each of these organs should operate independently of the other. None of the other organs should spread legs in the affairs of another organ.
That's what?
Yeah.
Spread.
Yes, you are stepping here and there. Yeah? Because at the end of the day, you will have a conflict of interest on whom to serve. You get
so the idea is no one should spread legs in the affairs,
of another. Each should operate independently. The Baganda say so that you cannot be a head of here and also here. So you can only be a head to one entity.
So that was Montesquieu. Yeah. Let there be the arms of government, but each on its own.
Operating independently of the other, without any other usurping the powers of another.
Is it relatable? We can relate to our constitution today?
Yes.
Oh, the creation of Article 77?
Yes, because if he is talking about the three arms that the legislature, when you look at Article 77, also Article 79 providing for the law
of legislation.
Yes.
And then executive
when you look at Article 98
and 99
giving power to the president.
And then 126.
Then 126 for the judiciary. Yes. So perhaps it is their ideology of Montesquieu that
led us to have these
influenced the framers of our constitution to include those articles. That was Montesquieu. So let's look at Johnny Roju. John Locke, for him, we came up with the idea of property rights. And we see he pushed for the Bill of Rights of, that is 1628 and also 1688.
So
yes, 1688, that one was, it came up with very many fundamental changes. So he came with the idea of property rights, that people should have a right to own their own property. You get. And he also talked about taxation, that the merchants, they shouldn't be subjected to any kind of taxation the state feels like. There should be representation on the kind of taxation they should be subjected to. And when you look at property rights,
we are on John Locke.
Yes, John Locke.
Property right and taxation.
And taxation, that's what he gave us. So when you look at property rights, you articulate it to Article 26
of the
right to own property.
Yes.
That a person has the right to own property. The person has to own a right to own property. And when you see it talks about taxation, representation in taxation.
We already have taxation.
Yes, and Article 152 and 153.
What people should know about taxation in all, wherever we find it, is one thing. These philosophers, all the ancient Greeks and others, they are advocating for fair taxes. There should be no a burden of taxes on other members. And you get to Article 152 and 153. Let's go to Jean Roju as the finalize.
Yes, Jean Jacquin Roju. For him, he came up with the idea of that power belongs to people. Rule according to the will of the majority.
Rule of law.
Rule of law. That if the government is to be there, it should lead people according to their will. It shouldn't be an imposed government. People should be ruled or led according to their will. And if the government cannot listen to what the people who voted it into power want, the people have mandate to overthrow that government and institute the one that is ready to do what they want. And how do we see that? When you look at Article 1 of our 1995 Constitution.
Power belongs to the people.
Power belongs to the people. You get?
Yes.
Power, people power. Yeah?
The idea power belongs to people. Power belongs to people.
Okay.
This channel, Kacharo Kangi Kato, okay, now, finally, let us briefly talk about the African setting in just a minute. African setting. Just summarize it.
Okay.
Because of time.
Yes. With the African setting, maybe the other I think we have forgotten about is the revolution that took place in Europe. We see the French Revolution
and the American War
of Independence. With the French Revolution, we saw them with the ideas of liberty, equality, and fraternity. Those were their battle cries in the French Revolution. Sure. And how do we see those ones after having attained them? We see liberty, Article 21,
Article 23, Article 21 equality, 23 liberty,
and then fraternity.
And then
the American War of Independence. That was 1774 to 1760. Still, for them, they were agitating for democracy and human rights.
That's why you related to Article
59
and Chapter 4 of the Constitution.
Yes, and Chapter 4 of the Constitution to do with human rights.
So, African setting.
Setting, finally. African setting, because all whatever you have seen earlier on is in the overseas. What did the motherland Africa have? For Africa, we had only two. That we had the centralized societies and the decentralized societies. And with the centralized societies, for them we see we had kingdoms. And to be specific, I can use Uganda as my case study. That they had the king at the top, they had that centralized system of administration. And that one perhaps explains why the British found it so easy to use the indirect system of governance. Actually, the British were very surprised to find the Baganda having a system that is a replica of theirs in Europe.
Continue.
So we see that with centralized societies, for them, they had the king, they had the clans, now they had also the Sabataka as the king. Now the king had their clan heads. They could report the what? The Bataka, the Womuruka, all those people were always
they had a system that they were working in.
Yes, so Womutuba, so they had that chain of leadership that was so interconnected up to the family. From the family you go to the clan, from the clan now you go to the Saza, from the Saza now you go the Saza chief would report directly to the what? To the king. So they were organized in that way. Their communities were communal in nature. They worked together. They used to work together.
So how do you relate their organization to the constitution?
Their organization to the constitution. We see that, for example, Uganda, they had their Luchiko. And when you relate the Luchiko with this current parliament they are having.
Oh, I understand. They had the way of resolving their dispute. They will come on fireplace around and resolve.
The Uganda courts
are also there.
They are also there, that used to settle disputes.
So that relates to
the judiciary, Article 126.
Okay. So members, we
also look at the decentralized societies.
Yes, okay.
What did the decentralized societies have? Here we can look at the Kikuyu, the Akamba. These ones, yes, they had the chieftaincies. That they were decentralized, very isolated. This clan does not collaborate with
the other one.
Yes, they were isolated in nature. That each clan operated in its autonomy.
Clan had things it does in its own area.
Yes.
The other on the other side, everyone on his own and God.
And they were always led by chiefs. Their setting, they had age sets. Age sets. They had the junior age set, the senior age set, and the elder of council.
So you see that leaders will be picked from the elders
from the senior age set. Okay. Leaders were always picked from the senior age set. And also the council of elders was always there to settle disputes between the senior age set and the junior age set.
So council of elder can now act as our judiciary today. Okay. Then the leaders being picked depending on their various. We have Article 1010, 111 that picks the Prime Minister, where President appoints ministers. Yes, depending on their different merits and qualities they are having. So, after discussing all that, our dear viewers, I urge you and implore you to go and make a search on Asian Mat. Asian Mat, yes. Please, Egyptian Mat. Egyptian Mat, kindly make a research because of time. Make a research on Asian Mat. Council Kabugo, we thank you so much for coming. Thank you for pouring wisdom. I'm glad that you have poured wisdom. I know people have picked and they will take this as serious. And year ones, we wish you exams wherever you are, whenever you go to your exams. We have wished you all success in advance. Please enjoy. Thank you for watching. Share, subscribe, like our videos. Thank you.